Okay, for state information, I think we know the definition of a brokerage and a broker already, and the definition of real estate. I would know the idea of an appointed agent. That's going to be you as a salesperson, for example. Your broker is going to appoint you as the agent to the transaction. So remember, all commissions, all contracts, those flow through the broker first. You will tie yourself to the transaction by being labeled the appointed agent. The other good one that's good for you to know is the term inactive license. Anytime your license is inactive for whatever reason, you're not selling real estate. That means that your license is being held with the Iowa Real Estate Commission, so you're not providing any real estate services. I would know who is excluded from needing a real estate license. If you're doing a for sale by owner, you don't need to do you don't need to have a real estate license. You can sell your own property and not have a real estate license. If you're working as a power of attorney for an estate, for example, I pass away, my sister's my executor, or I name her as a power of attorney. She could do this. That would be almost like a for sale by owner. She would not need a real estate license. The other one that I think might be notable for the exam is you do not need to have a real estate license if you're a property manager who lives on the premises and leasing the property is in connection with your employment. So if you live on the premises where you work. As an application for a broker, I think the highlights are you can't have had another license revoked in another state, real estate or non-real estate regarded, 18 years of age or over. They may ask questions about citizenship, sex, race, religion, marital status, etc., but that's not a reason to deny or be ineligible. I had that question, I think, of the last exam I took. Criminal convictions, again, serve your time, pay your fines, do your community service. If it was a felony, you must wait 5 years after that point. Moral turpitude 1. You've got to do 60 hours of broker courses. And you must also have been actively licensed as a salesperson for 24 months or 2 years. And do a background check. Now, it talked about reasons to revoke or suspend your license. Fraud when you got your license or making false statements on the application. Incompetency, fraud in terms of misleading or untrue facts about a property or anything that would be detrimental to the public. Habitual intoxication or drugs. Non-compliance with errors, having errors in admissions insurance at all times. And then I would add default on student loans or child support. That could be a reason to suspend your license. And it says anytime a salesperson is discharged from a brokerage and the broker sends their license back to the real estate commission, they are what? Inactive, not selling real estate. It talks about civil penalties. And the commission can do a civil penalty against a licensee of up to $2,500 per violation, and you're allowed 3 violations in 3 years. Some other big non-becoming activities an agent can do to get themselves into trouble is not disclosing dual agency. So doing dual agency, but not disclosing it to the client. Undisclosed dual agency. Accepting a commission outside of the transaction. Again, that money needs to go to your broker and be disclosed to all parties. Paying a referral fee to someone who is unlicensed. If the commission does have a hearing about a violation or a complaint that's been filed against you, they must give you 20 days notice. Dual contracts are illegal. That's where we present one contract to the lender and another one to the seller in hopes that we'll get just a cash payout. For example, again, trust accounts must be an interest-bearing account for real estate, and the interest gets transferred to the Iowa Finance Authority on a quarterly basis. And again, a broker is allowed to have $1,000 of their own money in that account just to maintain for bank fees, etc. Because we can't ever have a zero balance in that trust account. Again, all agents must carry errors and omissions insurance. I think you very well could have questions that relate to the idea of cold AC. So those are your fiduciary agent responsibilities of care, obedience, loyalty, disclosure, accounting, and confidentiality. I've had this question before multiple times on the same exam. You can represent yourself or immediate family in a transaction as long as it's disclosed. So you would write something like seller is licensed in Iowa, buyer is licensed in Iowa, or you would write agent is related to seller or agent is related to buyer. Some prohibited practices. One main one that I would highlight is asking for a referral fee after a contract has already been written. I absolutely encourage you to get referral fees. Refer your cousin in Carroll, Iowa to a great agent that works there. But you've got to be the procuring cause for it. You can't just ask for it when you find out about it at the Thanksgiving table next week. Seller disclosures must be made available prior to a buyer writing an offer or the seller accepting it. One great question for you on the exam, I think, is the mission of the Real Estate Commission is to protect the public. I'm on page 8. If any of you are listening in my through my Iowa licensing law little booklet. The mission of the Real Estate Commission is to protect the public. They're not going to deal with squabbles over commission dollars between you and another brokerage. You got to go to small claims court for that or something. A mediation program, anything. They're only going to deal with topics where the public was possibly put at harm. Your license requirements as a salesperson and as a broker are for 3-year terms. The first year counts as a full year, no matter what time you were licensed. To renew your license, you must have 36 hours of continuing education, 8 law update, 4 for ethics, and then 24 approved electives. 36 total, 8 law, 4 ethics, 24 electives. And you can renew without continuing education, but you're going to renew as an earnest. Now, there is a 30-day grace period for you to renew till January 30th, which is a $25 fee. They allow you to pay that $25 fee for 3 years after your expiration. But if you go beyond that, you've got to completely start over. The key person getting their license is they cannot be licensed as inactive. When you apply for your license, it must be active status, which means your license needs to be in possession of a broker. Renewals for salespeople and brokers are the same. Again, by December 31st, first year counts as a full year. 36 hours, 8 are mandatory law, 4 are mandatory ethics, then 24 electives. Deadline again, December 31st. If you don't, you can renew without continuing education, but as an active, you're allowed a 30-day grace period with a $25 fee. You can pay that $25 fee for 3 years. And after that, you've got to start all over. Now, when you're terminating your employment with a broker, you go in, you say, I quit. Take this job and shove it, right? They're going to send your license back to the real estate commission. You're going to be inactive, not selling real estate. However, if you really do choose to switch brokerages, there's a way for you to do it and still keep your license in active status. What you must do, I want you to think of this as a physical piece of paper, even though it's electronic now. Piece of paper, you get new broker to accept you. Then you have old broker release you, and then you sign it authorizing the transfer. So new broker sign, old broker releases you and signs, you sign it saying this is really what I want to have happen. That way we're not having brokers run their businesses like a draft pick and trading out players. You've got to actually sign and say, yes, you want to go to that new brokerage. Suspended and revoked licenses, another key thing to keep in mind is if your broker loses their license, you as a broker associate and salesperson are inactive as well. So death or incapacity, and they're not able to practice real estate, neither are you. If they get their license suspended or revoked, they're not practicing real estate, which means neither are you. So those are some other things, because I do know a couple of brokers in town that, man, their ship was sinking. And I said to a couple of their agents, you probably better move your license. Oh, no, we'll be fine. Said, no, really, if he loses his license, you immediately don't have one either. So I would get it put in a place so it doesn't interrupt your business. We talked about tying agreements being illegal, where we can't force a builder to buy our lot and then list the new house with us. He can hire us for both of those things, but it cannot be tied together as a stipulation to be able to buy the lot. It talks about furnishing a progress report to a client. This must be done on request. Again, if you're representing yourself or immediate family, you must disclose that in an offer. One main thing that a broker has as responsibility is supervision and having a written company policy manual. Just because he fails to be informed of what's going on doesn't mean that your broker has no responsibility for you. And when you hire an assistant for your business, the licensee has the main responsibility for them, but your broker has responsibility too. You're just the key point of responsibility. It talks a lot about permitted and prohibited activities for unlicensed assistants. And here's what I will keep in mind, what I want you to keep in mind. An unlicensed person can never share information about a property to the public, but they can to another licensee. They cannot make decisions about what vendors to hire and negotiate any terms with that vendor, but they can orchestrate the time. They can let the individual into the house. They can forward a receipt. They can make checks. They can also manage the trust account. Okay. They just can't hold fees under their own name. They can compute commission checks like that of an accountant type role. What they can't do is show properties independently, and they absolutely cannot do open houses independently unless it's a broker only tour. All offers immediately for acceptance or rejection. You must allow a client to have their agent with them every step of the way. You cannot deny a party having their agent present with them for anything during the transaction. Any record keeping must be kept in storage for 5 years. Your advertising must include 4 major elements: your name, your broker's name, full, no abbreviations. So your name, broker's name, the city and state where your office is located, and where you hold a license. So licensed in Iowa, or our friends in the Quad Cities areas are going to be licensed in Iowa and Illinois. Our West Coast families, they're maybe going to say, like Sioux City area, for example, they're going to say licensed in Iowa, Nebraska, and South Dakota. I've got a friend that's randomly licensed in Iowa and Arizona. Not sure why. Well, I probably know why. I'm on page 22 of this booklet. It says listing agreements must be in writing. They must be an express contract in writing. They cannot be oral. Automatic extension agreements are illegal. And in order to have a broker protective clause, it must be part of the original listing agreement, which most are pre-printed. The time frame must be specified. So I know a lot of agents that use 180 days as an example. And a list of all of the buyer contacts must be made available to the seller prior to the expiration date. We learned this one on the national as well, but relationships commence at the time the brokerage agreement starts and continues until closing or performance of the agreement. Otherwise, it's by expiration, mutual agreement, destruction of property, bankruptcy or eminent domain, and death or incapacity of either party. Either party meaning broker or client. Single agent representation, again, that is when you're representing only one party in the transaction. Dual agency is when you're representing both buyer and seller in the same transaction. We went through this with trust accounts already, but you've got a lot of good candidates for test questions in here. We cannot commingle between the trust and the general fund. 5 banking days to deposit the check unless agreed otherwise. The broker can do that $1,000 we've been talking about. It must be an interest-bearing account with the interest being transferred to the state on a quarterly basis. No funds can be distributed from the escrow account without written authorization of both parties being the buyer and the seller. A broker cannot hold any trust funds to cover commission fees, even if they were earned. Again, we must keep files for 5 years. Unless agreed otherwise, it's got to be cash or an immediately cashable check. So yes, you can use an item of value, such as a diamond ring, as long as it was part of the original offer that says earnest money is going to be diamond ring, attached as ring and appraisal receipt, right? Otherwise, it's cash or an immediately cashable check. And if a buyer writes an offer with earnest money and the offer is not ever accepted, that earnest money can be immediately returned to the buyer. For seller property disclosure, I'm on page 30 of this little booklet. Again, a disclosure must be made available to the buyer prior to them writing an offer or the seller accepting it. We really leave our buyers exposed if we would write an offer subject to reviewing the disclosure. I know what your intentions are there, but it doesn't give them an out other than reading it. And if there's something on there that worries them, they maybe wouldn't have written an offer as high as they did, but now you've put out their top dollar. So you've put them at a disadvantage. This gives a list of 19 items that are required on the property disclosure. I think it's more important for you to know who needs to fill this out. Anyone in charge of an estate or a conservatorship, they don't need to fill out the disclosure. Bare lots or more than 5 units don't need to fill out this disclosure. Now, property managers, again, we've got a lot of things that are similar to what we already know. Their unique differences are going to be that once their contract is up as the property manager, that broker must now notify all the tenants of who the new manager is and where their deposits are located. They cannot write a check that the owner's bank account can't cover, and they can't cover up their paper trail with just IOUs. Again, I think I use that example of Dumb and Dumber. They're like, do you still have the $1 million? Of course we've got it. It's all right here in this brown suitcase. And then we open up the suitcase, it's all IOUs. That's not what you can do. It actually has to be billings and receipts, not just a ledger. And then a broker cannot withdraw money in excess of what they know is in the owner's bank account. Those are 2 very specific, great questions for that exam. Now, this is our next spot is to really talk about groundwater hazard statement. Again, that's that GW Bush acronym that we talked about with the national side. That is groundwater, wells, water, burial sites, underground storage tank, sewer, including a private septic system, and H is hazardous waste. Now we've got a groundwater hazard statement that must be filled out with every transaction. The groundwater hazard statement is a form that is actually required by the Department of Natural Resources. It will come with your closing documents, okay? And it must be made available in order to record the deed. The transferor or agent can sign it. It says who can sign it. Technically, it's transferor or agent. I don't sign them. I have my clients do it, but it says either or. The third big thing for a test question around groundwater hazard, because you could have 3 or 4 on the state, is repairs are not required to be made or escrowed as a part of being able to record the groundwater hazard statement. If any of those groundwater hazard statement things exist on a property, if the buyer wants those repaired, it should have been negotiated during the home inspection period. This, again, is not a disclosure to fix things. It's something to keep on file for the Department of Natural Resources. You will have one question around the Iowa Civil Rights Act of 1965, which basically they did everything in the fair housing law 3 years sooner than that they did at a federal level in 1968. So those protected classes of race, color, national origin, Iowa says religion or creed, sex, disability, and family status. They just did all those things 3 years earlier, approximately. In Iowa, though, what is unique from the federal is they also protect sexual orientation and gender identity from discrimination in housing. And that Civil Rights Act of 1965 in Iowa was not just a civil rights law put into place for housing. It also included employment, education, and what they called public accommodations, which means we were not allowed to discriminate on buses, schools, well, that's education, bathrooms, buses, I forget what all I've said, but we couldn't do that whole separate but equal game anymore. Otherwise, all of your basic laws with fair housing that we discussed earlier are going to remain the same.